do this a little bit different. You think that it was appropriate. But I tell you, whenever you go there and you beat on his window and you put him in fear of physical injury,
I disagree with that.
Well, I wasn't here for that, okay?
She comes beating on my window, scares me to death. I had no clue. Jump out, she starts freaking boom, 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 boom. So I hit the recorder, start recording, and she's doing the way she's doing. I mean, she's yelling, screaming, she's disorderly.
I can hear it. I'll talk to you in a minute, okay?
36, report negative.
Interaction. On August 18th, 2023, Deputy Croft of the McCracken County Sheriff's Office in Kentucky was driving without his lights activated when he allegedly merged across two lanes without using a turn signal, nearly driver Juniper Mulligan, who avoided a collision by slamming on her brakes. Deputy Croft parked in a McDonald's parking lot, as did Ms. Mulligan, and she walked over to Deputy Croft's vehicle and knocked on his window to talk to him about his driving. As a result, Deputy Croft detained Ms. Mulligan and called for backup, and Deputy Crone shortly arrived on the scene. The interaction that followed was captured on Deputy Crone's body camera.
So, pull up. So, lady was driving. The cop almost ran off the road or ran into her, and she goes to where she was going. It just so happened that the cop happened to be there too, and she decides, I'm gonna tell you about your driving, and this is where that ended up.
I went in the car laying over here. I guess I cut the phone over. Never seen her over there. Of course, I can't say a whole lot of that. She comes up here.
He's a liar. You can already tell he's a liar. And the way he goes about everything is going to be just off. You can tell that just by how he presents himself right now.
She comes beating on my window, scares me to death. I had no clue. Jump out, she starts freaking boom, 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 boom. So I hit the recorder, start recording, and she's doing the way she's doing. I mean, she's yelling, screaming, she's disorderly. I think for disorderly.
36. Do you have this 23 last name?
Negative.
10-4, got it. I can hear it. I'll talk to you in a minute, okay?
36, report negative.
The first thing that he's supposed to do is identify himself.
Do you have a name?
Do what? I do have a name.
What is the name?
I told you I'll talk to you later.
Negative.
So the contract, big Miranda, we might have minutes. That's a minute. I would have say that's a minute. Window like that? Yeah. Is Mulligan? Turn around. Back.
What?
Disorderly conduct and menacing.
Menace.
Deputy Croft informs Ms. Mulligan that she is under arrest for disorderly conduct and menacing. According to Section 525.060 of the Kentucky Revised Statutes, quote, a person is guilty of disorderly conduct in the second degree when, in a public place and with intent to cause public inconvenience, annoyance, or alarm, or wantonly creating a risk thereof, he engages in fighting or in violent, tumultuous, or threatening behavior, makes unreasonable noise, refuses to obey an official order to disperse issued to maintain public safety in dangerous proximity to a fire, hazard, or other emergency, or creates a hazardous or physically offensive condition by any act that serves no legitimate purpose. Now, even assuming for the sake of argument that Ms. Mulligan made unreasonable noise, the disorderly conduct statute requires that the individual act with intent to cause public inconvenience. Section 525.010 of the Kentucky Revised Statutes defines public as meaning, quote, affecting or likely to affect a substantial group of persons. This means, as the Sixth Circuit Court of Appeals, which has jurisdiction over Kentucky, explained in the 2011 case of Kennedy versus City of Villa Hills, that Now, quoting, Kentucky law does not criminalize arguments and noise that disturb only police officers because such conduct does not risk public alarm. Indeed, because the First Amendment requires that police officers tolerate coarse criticism, the Constitution prohibits states from criminalizing conduct that disturbs solely police officers. Similarly, the Sixth Circuit held in the 1997 case of Barrett versus Harrington that, quote, it is evident that the First Amendment right to criticize public officials is well established and supported by ample case law. And that, now quoting again, freedom to criticize public officials and expose their wrongdoing is at the core of First Amendment values, even if the conduct is motivated by personal pique or resentment. As such, it is highly unlikely that a court would conclude Deputy Croft had probable cause to arrest Ms. Mulligan for disorderly conduct. Now, as for a menacing charge, Section 508.050 of the Kentucky Revised Statutes states that, quote, a person is guilty of menacing when he intentionally places another person in reasonable apprehension of imminent physical injury. Now, while it is possible that Deputy Croft was startled by Ms. Mulligan knocking on his window, this conduct almost certainly did not rise to the level of menacing, as there could be no fear of an imminent physical injury given the physical separation between Ms. Mulligan and Deputy Croft. Likewise, any so-called apprehension that Deputy Croft may have experienced could not be reasonable, as knocking on a window is a commonly accepted way of getting a park driver's attention and is not a threat of violence. Finally, it is abundantly clear that Ms. Mulligan was intending to try to speak with Deputy Croft, not place him in fear of imminent injury. As such, it is likely that a court would also conclude that Deputy Croft did not have probable cause to arrest Ms. Mulligan for menacing.
This is funny. Okay.
Don't
I'm going to do it.
Put your hands behind your back.
You want my keys home? Yeah, take my keys.
Hold up. Don't be ripping anything out of her pocket.
Why?
Back up.
We'll give it to you, but don't be jerking out until we know. We don't know what you're pulling out of your.
You know, hey,
Okay, then have a seat. Yeah, actually, we can't. You're under arrest.
You're under arrest. Stop it.
Oh, that's my dog.
I'm double locking these cuffs so they don't tighten up on you, okay?
Whatever you
Get
do.
it fucking up. Anything on them?
All right, I'm going to walk you back here, okay?
I would like to give my mother my keys now.
Okay. That was,
I would like to give my mother my
no,
keys.
so you're not going to do it. You're handcuffed, okay?
I know.
So,
I want my
okay, so
mother to go in my
listen
pocket.
to me.
No,
You're under
I want
arrest. So
her
this is
to
a
take
search incident to arrest, okay? I'm lawfully able to search you after
Okay.
you've been placed under arrest, okay?
Sure.
I understand, but I'm just telling you how it is. So, obviously, I was the initial officer who was out here, so I'm going to make sure that he's okay with her having the keys, and if he's okay with it, then that's what we'll do, okay?
Sure.
Just want you to know, okay, I'm actively recording right now, so what I'm going to do is I'm going to search you well enough to ensure that you don't have anything that's going to harm me, okay? Is there going to be anything that's tucked on you that the jail's going to find
Sure.
when the officer searches you?
Could you imagine that? Like, you going to tell somebody about their driving and you end up going to jail for that. And the person who was taking you is the person who actually almost, harmed you. I'm not going to say killed you, but they almost harmed you. It could have been a terrible accident. And you go tell them that they had bad driving and you end up going to jail for that. That's insane.
Nope.
Okay, I appreciate the honesty. I think that's everything. Right, I don't know.
Me too. May she have that?
Yeah, we can catch sure.
And I would like, no, that's my wallet. My wallet is in my back pocket.
Okay. So wrap this up.
Mom?
Check signal this up.
I'll get the door.
Yeah, send it.
Mom, come take these things from me, please.
Alright, so you do want your mom to have cash, correct?
I want her to have my keys, whatever's in my pockets.
Yes.
I'd like to keep my chapstick though.
Make sure there ain't nothing folded up in here. Alright, is there anything in your back pocket? Right side.
Yeah, there's my wallet.
Your wallet in your back pocket. Can you go ahead and just grab that out with your left hand?
Sure.
No, absolutely not. Okay, yeah, come here. You're on.
I was just near my property. from my mother.
33 for check welfare.
Space to do. Yeah. Okay.
22 236 Homewood Avenue.
Take some side steps
Caller
to your
providing
left.
there's a female possible 218A. 218A.
What I'd like to do is I want you to spread your legs just like this. Okay.
We're currently public coverage right now, saying she's going to harm pets and chickens in the area, unknown weapon. Via shoulder length, hair, black shirt, white shorts with flowers and cross.
Hey, unless you want to go in cuffs, give me those keys. Stand over there. Stand over there, or you're going to be arrested for interfering in this investigation. Stand back.
I'm just got her keys.
You're not grabbing anything on this car. Stay there. Do not touch the keys.
Excuse me. I'm not a freaking dog.
I have a wand right here. This is a metal detector. Okay. Okay, you spread your legs back. I want you to turn around and face me. I'll take your hat off. Over that AC. Good. Yeah, I don't know why they're doing this today, but we're good. I'm going to read you something because you're currently placed under arrest, okay? You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney before making any statements and have your attorney with you during questioning. If you cannot afford an attorney and desire one, the court will appoint one for you. You may stop the questioning at any time by refusing to answer further or by requesting to consult with your attorney. Do you understand each of these rights that I've explained to you?
Yes.
Keeping these rights in mind, you know you don't have to talk to me and you can invoke these at any time.
All right.
You wish to talk to me about what happened today?
Yeah, once they reach you that, you shouldn't say nothing to them about anything.
That led to this? Because it's honestly, I don't know. I rolled up here and this.
It's honestly, I don't know. All that's BS. After they reach you that, don't say nothing. It's nothing to talk about. Yeah.
The situation was already happening.
All right. Will it affect my arrest?
Do what?
And she said, will it affect her arrest?
Will it affect this? Do I get out?
No.
No, it won't help you get out. So it won't help you get out of the situation that you're in. So it's at this point, I wouldn't say nothing.
Okay, well, that cop whoever cut across 2 lanes of traffic
We're at over here on the road.
on the bridge. Cut in front of me across 2 lanes of traffic, no lights, no signals. And I honked at him, and then I came here to tell him he was a bad driver, and this happened.
Tell me how you went about telling him that he was a bad driver. I believe that's where the problem's going to
I just went
lie.
up and knocked on his door. I knocked twice on glass. That's it.
We could have went about this in a better way. You know that you can just go to the sheriff's department and say, hey, I want to talk with the sheriff. I've got a problem with what happened today on the road. Do you realize that's the way to go about this? Because listen, let me tell you something. I do not enjoy taking away people's freedoms. I did not get in this job to do so. And I hate that this is what it's come to today, okay? But I wish that on your side as well, I wish that we could have done better today.
All I was going to do was let him know he cut across 2 lanes of traffic. You know, if you're supposed to uphold the law, you should, actually follow the law.
I agree.
You should be aware of the laws he's trying to enforce.
But let me ask you this. Would you agree if we could go back in time?
If you agree with what she is saying, why is she in the back of a police car with handcuffs on and you just read her rights because she's under arrest? If you agree with her, that makes no sense, because if he actually cared about the law and cared about what's right or wrong, she wouldn't be in the back of a car right now.
do this a little bit different. You think that it was appropriate. But I tell you, whenever you go there and you beat on his window and you put him in fear of physical injury.
Okay, I disagree with that.
Well, I wasn't here for that, okay? I appreciate you being.
He was in fear of physical injury. Look at her. Like, what's wrong with you, man? How scary are you? Imagine somebody. Imagine a man in this situation.
You're nice and cordial with me and talking to me. I promise I'm not a mean person, okay? I'm going to do my best to be able to have your mom take the car where it doesn't get towed. Okay?
I appreciate that.
All right. I'll be back with you this morning, okay? Can you feel the air?
Yes.
Okay.
After reading Ms. Mulligan her Miranda rights, Deputy Crone questions her about the incident. As we have discussed before here on ATA, the Supreme Court held in the landmark 1966 decision of Miranda versus Arizona that officers must inform suspects of specific details regarding their legal rights under the Fifth and Sixth Amendment before they can subject them to so-called in-custody interrogation. Although the initiation of a formal arrest will generally render a suspect in custody for the purposes of a Miranda analysis, courts have also found that Miranda warnings are required in some situations where a citizen is in custody but not formally under arrest. As the Supreme Court explained in the 1995 case of Thompson versus Cohane, quote, two discrete inquiries are essential to the determination. First, what were the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt he or she was not at liberty to terminate the interrogation and leave? Now, in this situation, Ms. Mulligan had been formally arrested, handcuffed, and placed in the backseat of a police vehicle, so it is virtually inarguable that she was in custody and that were required to interrogate. However, there are circumstances where Miranda is implicated even if a formal arrest has not been conducted. Conversely, courts have also determined that who are placed into the back of police vehicles are not always considered to be in custody for Miranda purposes. As the Sixth Circuit Court of Appeals explained in the 2007 case of United States versus Wright, quote, merely placing an individual in a police car does not automatically transform a Terry stop into a formal arrest. Instead, we look at the totality of the circumstances, focusing on the purpose of the questioning, whether the place of the question was hostile, coercive, the length of the question, and other or to request the officers to do so, whether the suspect possessed unrestrained freedom of movement during questioning, and whether the suspect initiated contact with the police. Therefore, even though Ms. Mulligan was almost certainly in custody at the time of this interrogation, there may be situations where officers are not required to give Miranda warnings prior to questioning citizens that they have placed in police vehicles.
Yeah, I'll open the window. She can talk to you. Would you like to come speak with her? You can talk to her, say whatever you'd like. I just ask that you don't reach in there or take anything. Just talk, okay?
What? I still have my chopstick. Here's some tea. How you doing?
Could be better.
Like I said, I searched you. You're a woman, so I'm not going. I searced you well enough to make sure that you don't have any knives, guns, or anything that can hurt me. Okay? The chapstick that's in your pocket, you can just leave it there. Okay? It's okay.
Let me know the incidentals.
You'll just probably ROR right out. Okay?
Probably what?
You'll probably just ROR right out.
I don't know what that is.
They're basically going to go up there. They're going to take your information, and they're going to release you on your own recognizance to come back to a court date.
Okay.
So
I have no way home. I've got 7 animals I got to take care of.
all right. I'll make sure I let them know. I think we're going to be able to do that. So, but I've got to go over there and talk to them. So I'm rolling the window up. So just kind of hang back over there in the shade. Do you want this with mom or not?
Yeah, she can have it.
Okay. Real quick.
Well, once they turn off the audio, you know that was for a reason, and this whole situation is corrupt, and everything about this is wrong. Whenever they don't want whenever they hit mute or they turn off their body cam or anything like that, you already know that what they're doing is wrong.
Your mom. I don't think that it was a good idea of what daughter did today.
I
Just
know
like I was
that.
telling you, just like I was telling her. She even said, she said she'd go about it different. I'm gonna put your seatbelt on you. Just go straight down, okay? Are those cuffs okay on you right now?
They're not really comfortable.
Well, they're not designed to be comfortable, but like, is your hands okay right now? They're not like numbing out or anything?
No.
All right, well, we ain't got that long. It's just a little short. Oh, there it goes. All right, we're gonna go up there.
Ms. Mulligan was transported to a county jail where she spent the night before being released. Ms. Mulligan alleges that during her time in jail, she was forced to sleep on the floor of a crowded room, and that a jailer found a snake in the building and brought it to her cell to show the detainees. Ms. Mulligan fought the charges against her, and they were eventually dismissed. Ms. Mulligan also expressed serious concerns regarding inappropriate sexual advances and the mental health of the public defender assigned to her case. These allegations are discussed in detail in Lackluster's coverage of this encounter, which I've linked in the description down below. The charges were expunged in December of 2023, and Ms. Mulligan filed complaints with the jail and the McCracken County Sheriff, the results of which are unknown. Ms. Mulligan also filed a lawsuit, and the case was settled for $25,000, $5,000 of which Ms. Mulligan donated to a domestic violence crisis center. Overall, Deputy Croft and Deputy Crone get an F for arresting Ms. Mulligan without any legitimate cause to do so and demonstrating a clear deficiency of knowledge regarding Kentucky criminal law and the Constitution. Deputy Croft also maintained a belligerent and unprofessional demeanor throughout the encounter. And while Deputy
They lucky it was only $25K, and that's probably because they didn't take it further than it needed to go, and they offered her 25, and she probably said, "I'll go ahead and take that," but could have been. We already know that everything about this was wrong.
Crone did behave more politely. He not only completed the unlawful arrest of Ms. Mulligan, but repeatedly scolded her for simply trying to approach a police officer in public to voice her concerns. It is not illegal to knock on a police officer's window, as any reasonable officer would clearly understand. And it seems that this arrest was yet another instance of the infamous offense of contempt of cop. Ms. Mulligan gets an A for attempting to confront Deputy Croft about his dangerous driving behavior, maintaining a relatively calm and respectful demeanor throughout the interaction, and complying with the arrest and challenging its validity after the fact. Ms. Mulligan's conduct during her blatantly unlawful arrest is an excellent example of how citizens should behave when they are unconstitutionally arrested, particularly in states like Kentucky, where citizens can be convicted of resisting an unlawful arrest. And although I would have preferred to see Ms. Mulligan invoke her Fifth Amendment rights when Deputy Crone interrogated her, she did not admit to anything incriminating because she had not committed any crimes. On the whole, Ms. Mulligan did an excellent job balancing compliance and verbal dissent, and I applaud her for fighting the criminal charges against her and taking appropriate civil legal action to hold the deputies involved accountable. Let us know if there's an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for
All right, I'm gonna go ahead and end this stream. I appreciate everybody for joining me and watching these videos with me. And if you can, go ahead and grab my book off Amazon, Eyes on Authority, How to Hold Public Servants Accountable from the Streets to the Screen, documenting the fight for freedom. So it's basically, this book pretty much is about the First Amendment and continuing to make sure that you are exercising your rights. You got to know that if you don't exercise your rights, they're likely to walk all over them. With that being said, AWB, I'm out.